on the federal courts of appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Abdication at the Center for Injustice.
No, that's just a little Halloween joke, everybody. No, this is the Center, of course, for Judicial Engagement at the Institute for Justice. And we are joined here this week with two of our friends at the Institute for Justice who will tell us some spooky stories in this, our last episode that we'll release before Halloween. We're recording this on Thursday, October 26th, 2023. And our chief ghost storytellers, who will tell us some spooky tales of conversions of land use stymied by zoning and oral arguments before Judge Easterbrook of the Seventh Circuit. I mean, nothing can be scarier than that in the federal courts of appeals. Our two ghost storytellers are Erica Specter Smith Ewing and Bert the Ghoul Gall. Welcome to both of you to Short Circuit.
Thanks for having me.
Thanks, Anthony. It's good to be here. I was a little worried about your voice for a second there, but
yeah. Well, I think we've excised the demons from the studio here, and we'll be okay going forward. But I do want to warn listeners that there can be some spooky elements coming, nevertheless, and so please be ready for that. If you're driving, you might want to just keep your eyes on the road. Because there are going to be some scary elements of constitutional law coming your way. Now, first, we're going to start out in the 10th Circuit with Erica's case, Van Sant versus Town of Calhan, which sounds like a pretty scary place in Colorado. Tell us a bit about that, Erica, and what happened there.
Yeah, so this case definitely has scary elements, or at least it was certainly a nightmare for the plaintiff. The plaintiff ran a mobile home park in a small town. The town is Calhan, Colorado, but the plaintiff's business went belly up, and the plaintiff argued it was because of new ordinances passed by his local government. He argued that the local officials passed these ordinances to protect their own business from competition, which put him out of business. This case has some pretty disturbing facts, but nonetheless, the 10th Circuit ruled against the plaintiff and granted summary judgment to the government. So let's get into the details. Calhan, Colorado is a small town of only 760 people. It's in the middle of the desert. And if you Google image search it, you can see why people want to live there. It's fantastic scenery, very unusual rock formations, beautiful. And I'm guessing that's why Calhan is a popular destination for recreational vehicles, aka RVs, because it's so pretty. And that's going to become relevant in just a moment. So the plaintiff had a mobile home park where he's rented space to a bunch of mobile homes. And more recently, he also started renting out space to RVs. And for listeners who don't know, a mobile home is more of a permanent structure, but RVs are more vehicles or connected to a vehicle. So people often ride around in RVs for vacation. So the plaintiff had RVs, and in addition, there were two RV parks in town. One was owned by the Chouse family. I think that's how you're pronouncing it, Chouse. Calvin and Annette Chouse. Now, the Chouse family didn't just have an RV park. They had other businesses, plus there were three Chouses in the local government. So Calvin and Annette, their son was the former mayor. He was also the current town council member. And Calvin and Annette also had two grandchildren in local government. One was also a town council member, and another was a member of the local zoning board. So it's hard to keep track of all the family tree, but suffice to say is we have a lot of Chouses, and they seem to have their finger in everything in this very small town. I think you see where this is going. Up to this point, RVs and mobile homes were both virtually unregulated, but a few months after the plaintiff started adding RVs to his mobile home park, a couple of things happened. First, the town passed a law that mobile home parks could not have RVs anymore. And then the town cites the plaintiff several times over the next year for having his RVs. So the plaintiff decides he's going to focus on just RVs. So he actually evicts all of his mobile home tenants, and just so he can have RVs. And this is where things go very bad for the plaintiff. The town passes another ordinance about RVs, and this time the ordinance makes it very, very difficult to have an RV park or otherwise provide parking for RVs. You have to satisfy a whole bunch of health and safety and aesthetic requirements that probably cost something in the hundreds of thousands of dollars for the plaintiff to implement. We're talking about complicated regulations about utility hookups, fire safety, even requirements for sidewalks and common areas. But importantly, this new ordinance has exemptions for the existing RV parks in town, including the RV park owned by the Chouse family. So in other words, the Chouse family RV park can continue, no problem. They don't have to comply with any new regulations, but the plaintiff can't start his own RV park unless he spends an arm and a leg. So plaintiff argues, hey, this is pretty suspicious. Not only do these regulations seem to be benefiting the Chouse family, but if you look at who voted for these regulations in the local government, 2/3 of the vote to pass them came from the Chouses. So they probably wouldn't even have passed if not for the Chouses. The Chouses also did not publicly disclose that they had this family RV business. And there's a strong argument that the state law required them to not only disclose this, but recuse themselves from the vote, which they did not. So here's another juicy detail. Not only are the Chouses passing laws that benefit their families' RV parks, but there's some evidence that the Chouses and local government actually would inherit this RV park when Calvin and Annette, their grandparents, pass away. Some dispute about that, but overall pretty shady. So plaintiff is not happy, and he brings a lawsuit in federal court. And he brings 3 claims. He brings a monopoly claim under the Sherman Act. I'll admit I'm not an expert on that, so we'll just go over that very briefly. He also brings a substantive due process and an equal protection claim. We do a lot of those at the Institute for Justice, so I'll spend the most time discussing those. Ultimately, the district court rejected all the claims, and the 10th Circuit affirmed. All right, so the Sherman Act. So plaintiff claims that the local government and the different Chouse officials were violating the Sherman Act because it passed the ordinance, in his argument, to create a monopoly to protect their own business. But the court refused to consider the merits of this claim because it reasoned that these were official government acts, passing the ordinance, and the government officials are protected by immunity for passing them. And the court found they were protected by immunity because essentially, these are official acts, and they're allowed to get away with this. Now, I think the court's reasoning is a stretch here. There's a good argument that it's not an official act because the Chouses arguably violated state law in voting for the ordinances instead of recusing themselves. But again, I'm not an expert on the Sherman Act. I'll let the audience read the opinion and decide for themselves. All right, let's jump into substantive due process. So just a refresher, the question under substantive due process is whether the challenged ordinances are justified by a legitimate government interest. Now, the town says, well, of course these ordinances are justified by health and safety reasons. And the plaintiff says, yes, health and safety, that's a totally legitimate government interest to have, but that's not your sincere motivation here. Instead, it's pretextual. You're really just trying to keep me out of business to protect yourselves from competition. Strikingly, the 10th Circuit says point blank, that the asserted rationale for the law does not have to be quote-unquote sincere. All that matters is whether there's a conceivable justification for the ordinance. And the
refreshing honesty there, I would say.
Yes. Not the first time the 10th Circuit has been refreshingly honest on government corruption, but we could talk about that another time. The court says it's at least conceivable that these ordinances are justified by health and safety, and it comes to that conclusion really without doing any analysis or discussion at all. In fact, the court doesn't even really discuss the regulations or why they were even needed. For example, the RV parks had been operating in this town for decades, unregulated. There was no evidence that any of them had ever had a safety problem ever. And of course, as the plaintiff argues, if these regulations actually were needed for safety reasons, why did the town exempt the 2 existing RV parks, including the Chouse RV park? If this is really a safety problem and these ordinances are needed for safety, you would think everybody would have to be regulated. Unfortunately, the court cites some Supreme Court precedent giving a lot of deference to grandfathering and these type of exemptions, so the court barely considers these exemptions in its analysis. Court, again, just concludes, as long as it's at least conceivable that the new ordinance would benefit public safety, it's A-OK. I have a lot of thoughts on this. We'll get to that in a moment. Next, the court rejects plaintiff's equal protection claim. The question under equal protection is whether the town is treating plaintiff differently than similarly situated RV parks. Predictably, plaintiff argues, of course you're treating me differently. These two other parks are exempted and I have to comply. It's going to cost me hundreds of thousands of dollars. But again, as I just noted, lots of federal case law saying grandfathering doesn't violate equal protection, so the court rejects this as well. All right, so what are the takeaways? IJ does quite a lot of constitutional challenges in the zoning and land use context, very similar to those in this case. And this is why I think the plaintiff lost. First, there were a couple of weaknesses in the case. You can infer from the opinion that plaintiff was not the most sympathetic of plaintiffs. Apparently, he had been cited by the town for having a lot of junk in his mobile home park. He apparently had some shady utility hookups. It seems the plaintiff later fixed up the property, but he's portrayed a little bit like a slumlord, and that may have left a sour taste in the judge's mouth. But I think the bigger weakness is that there was no smoking gun. Reading between the lines, the plaintiff's depositions didn't go great. There wasn't any direct evidence that the Chouses actually did pass the ordinance to benefit themselves. For example, no emails or testimony that the Chouses had been talking to their grandparents about the ordinances or that the grandparents had tried to influence the government. Instead, we just have speculation, or at least that's what the court says. But I think we really have to consider common sense here. There is a very strong inference, of course, that the Chouses were thinking about their family RV park when they passed regulations about RV parks. And I think most local officials are sophisticated enough not to put their bad behavior in writing. I think it would have been remarkable if we found an email saying something like, "Hey, Grandpa, we got the ordinance passed for you. Yay!" But maybe I'm jaded about this. I wasn't there. Maybe the Chouses are the most upstanding citizens in Colorado. But I think at the very least, the existing evidence was enough to send this case to a jury instead of being decided on summary judgment. But I think the most disturbing thing about the opinion is something else. And that is, even if there was a smoking gun, the 10th Circuit strongly suggests that the plaintiffs would have still lost. The court said it didn't matter if the town's asserted justifications for the law were not, quote unquote, sincere. Instead, the court says that under the rational basis test, as long as the rationales for the law were objectively reasonable, plaintiff still loses. And worse yet, the opinion's articulation of what objectively reasonable is so incredibly deferential to the government that pretty much any ordinance ever would satisfy the standard. So in other words, even if there was a smoking gun, the Chouse family passed these ordinances to benefit themselves, and that the health and safety justifications were actually protectual, it wouldn't matter under the court's reasoning. As long as it's at least conceivable that these ordinances might benefit the public, the ordinances survive scrutiny. This is obviously a huge problem and exactly why at IJ we work so hard to change how the court uses the rational basis test. Some courts use the rational basis test just as a rubber stamp for the government, and that's exactly what happened here. And it lets the government trample people's rights.
Bert, did this leave you quaking in your boots after getting to the end?
I thought it was chilling. And I think Erica is right. Common sense would lead you to believe that there is something rotten going on behind the scenes in terms of like this family's power and influence in the town. I wonder, like the inability to find a smoking gun. I wonder how much of that was the product of objections at depositions about legislative process privilege. Where basically they said we're not going to give you any internal documents, any internal deliberations, and that can be a real obstacle when you are trying to find that smoking gun, when you are trying to confirm that common sense observation that this just doesn't smell right. And so, I don't know how much of that happened at the district court. I'd be interested in that, because when you stack that privilege on top of rational basis, you've created a real barrier to vindicate economic liberty. It's a 1-2 punch that's very difficult to overcome unless you have some truly excellent lawyering, and I don't think the plaintiff had that here. I think Eric is also right that he did not cut a sympathetic figure for the court. But the 10th Circuit noted that the magistrate judge, I think this was tried before a magistrate judge, or originally before a magistrate judge, noted that there was some unethical behavior below. But the 10th Circuit just kind of sweeps that aside. When I read a decision like this, I keep thinking about Schoolhouse Rock. You remember like how a bill becomes a law. We watched that when we were kids, right? And it presents this pristine version of the legislative process. Everyone's operating in good faith to serve the public interest. There's no corruption. A bill is enacted, it's signed after considered reason and debate. And we all know that that's not actually what happens. It's a fiction. But here, I think the court, and I'm not singling out this court, I think a lot of courts don't want to look at what really happens, when the sausage is getting made. And it's that refusal to look that, will help or hurt folks who are trying to vindicate economic liberty. You really need courts to look with facts. And I think looking at facts includes looking at the legislative process.
I think I totally agree with Bert. I think another takeaway is, regardless of whether there was corruption in this case, this opinion just shows how much power local governments have to break a business. And yet so many people don't pay attention to local politics. So please, vote in local elections. Pay attention to what your local government is doing. They can change a lot of people's lives.
Yeah, show up at a meeting, where this is being talked about, and say, like, are you guys actually serious? Maybe if someone had done something like that, things might have gone a little differently. I always talk about that Schoolhouse Rock episode as a fairy tale. It's a fairy tale that we like to tell ourselves about how the legislative process works, and it's basically at the core of modern constitutional law, especially when the rational basis test is before us. One other aspect of the rational basis test in this case that true old time followers of IJ will recognize is Powers versus Harris. Another 10th Circuit case is cited a couple times. It's cited basically for just kind of how the rational basis test works, and the court uses the real strong version of the rational basis test, as Erica was saying, from this infamous case, FCC versus Beach Communications, that says you can just make up reasons that the legislature had without even looking at real facts. And that, of course, that's what the court does here. But it's interesting. It doesn't cite Powers versus Harris for what we all remember it saying, which is it's a very rare case that says that government protectionism of one party in support of one party and against another is a legitimate government interest. And most courts are not willing to go that far, and a handful of courts have actually rejected it and said Powers was wrong about that. And the court could have used Powers in that way, but I think maybe it realized that would just be a little too much. And maybe, the 10th Circuit went a little too far when it did Powers. So instead they go with this, hand waving, health and safety, yada, 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 approach to the rational basis test. So it doesn't have really a different result for this poor property owner, but it is a different way of getting there.
One might say that the spirit of Powers has possessed this opinion.
Yes. And so we need a method of excising that spirit from from the 10th Circuit, but apparently it's not going to be right here. So that was a very spooky tale. I'm going to have a hard time getting to sleep tonight, Erica, thinking about what happened with that RV park. But I think Bert might just be able to top it with his jurisdictional yarn that he's about to tell. So take it away.
Yes, I mean, when I was a kid, my nightmares came from watching the Nightmare on Elm Street movies. You remember those with Freddy and Don't Fall Asleep?
I purposely avoided all of those.
Yeah, 1, 2, Freddy's coming for you. You remember that?
Scared anyway.
Well, as a lawyer, your nightmares change. You wake up in the middle of the night, you worry that you've missed a filing deadline, that you left something important out of a brief, that that you're just not ready, for something that's coming up. The nightmare where you wake up and you've got oral argument and you don't even know what the case is about, right? Like I think every lawyer's probably had those.
Or you're back in law school and you never went to class or read the exams the next week.
Yes, but this features this case here, East St. Louis versus Netflix, features two types of nightmares. The first nightmare is one I'll use to set the background for the case, which is that across America, Americans are cutting the cord from cable. And this has big implications, not just for cable companies, but for municipalities who collect what are called franchise service fees. Because, when the cable company, they dig, they put in cables and wires and lines. And for the privilege of occupying public rights of way, cities charge the cable companies for this. And the typical situation is where, the cities will get a small percentage of the cable company's revenue. In this particular case, it was 5%. So the city of East St. Louis, which is actually in Illinois, and all Illinois municipalities get about 5% of revenue from the cable companies. And they rely on this revenue stream. And it is a big deal that across the country, people are cutting the cords because suddenly the cable companies, that revenue goes down, so do the taxes or the fees that they're able to collect. And so I was unaware that there has been litigation across the country in several states, both state and federal court. It's an issue that's reached, for example, the Ohio Supreme Court, the Tennessee Supreme Court, on this issue of whether municipalities can force Netflix, Disney, Paramount Plus, Hulu to pay these fees. And the question is really, is Netflix a video service provider? Is Disney Plus a video service provider? Under the law, people have always understood video service providers, they're the people who own the wires. They own the cables. It is the cable company. What cities are trying to do is convince courts that it's not just the people who own the wires, own the cables. It's the people who use the internet to put out content. And if that content just happens to go over cables, then those content creators need to be charged. This is
Can I ask a point of clarification here, Bert, which I read the case and was still confused by this. If you cut the cord, but you're still getting, of course, internet service, and so you're using streaming or whatever, right, does the internet service provider have to pay this fee, or do they not, even though you're getting the internet through those same cords from your ISP instead of, but you're not getting the actual cable? Is that how it works?
I think these statutes, so many of them were written before we got internet delivered by our cable companies. And you can buy internet service from your cable company separate and apart from your cable service.
Right.
And it looks to me that, at least in the statutes here, that internet service providers have not been charged for the the use of the wires, the use of the cables. And if you think about it, Netflix is putting its content out there on an open circuit, the internet, right? You don't need to have a cable subscription in order to access internet. You can access it from your laptop. You can access it from your phone. It's just that the way that a lot of us, access that content is through the internet and the cables that the cable company has installed. And so that's how we get it. I was left with the question after this case of like whether are we going to see states, for example, trying to go after internet service providers and say, to the extent that these cable companies own the cables and they're providing internet through them, we're going to charge for that. And we'll see if that happens down the line. But it looks like we're dealing with this kind of antiquated model that just doesn't take into account the internet. And it would have big implications if municipalities were to win under these statutes, because we stream everything. And as the Seventh Circuit notes in its opinion, this would have implications for the New York Times. They stream video, Major League Baseball, every streaming service that's out there. They would have to pony up, and of course those costs would be passed on to the consumers and make streaming less competitive. Also, I don't think it's noted in the case, but at oral argument, it's noted that typically under these laws, cable companies have to have a physical office in a jurisdiction, for customer service. At least that's the case in Illinois. And so the implications of the city of East St. Louis winning this case would be that Netflix would have to set up an office in every single jurisdiction, in Illinois. So it's pretty absurd, I think, reading of the statute. So it looks to me from the brief research that I've done, it looks like these challenges under kind of these old statutes have been just beaten back at every turn. Usually beaten back for one of two reasons. One, look, internet service providers are just streaming content that's created by Netflix. Netflix doesn't own the wires or anything like that. Come on, they're not video service providers. And the second two is, who has an actual right of action here to enforce these laws concerning cable service? And a lot of courts will say there's no private right of action here. The cities cannot bring a lawsuit.
Don't they have a cause of action just through claiming they don't get the tax, though?
Yeah, apparently the way these things are worded, in fact, this actually, the Seventh Circuit notes it here, that the private right of action argument was one, actually, I think actually it was waived at the trial court level. But a lot of other jurisdictions where it has not been waived have said, no, there's private rights of actions to do other things, but not when it comes to these, not when it comes to these fees. And a lot of it too is before states passed some of these laws to say basically municipalities get a certain percentage. The problem was municipalities were kind of doing their own thing. And so you had this patchwork of fees. And so I think the state wanted to kick that up to its level. And frankly, I'm sure the cable companies wanted that as well. So anyway, there's this big national legal battle going on over this that I was completely unaware of. And so that's obviously scary for municipalities to lose this revenue. But now we get to the scare of oral argument. And I had to listen to this oral argument after reading the decision, because the first several pages of this short opinion are based on the issue of jurisdiction. Can this court even hear this case? The city of East St. Louis, again, it's in Illinois. It sued all of these streaming companies, Netflix, Warner, Direct, Disney, and it sued based on diversity jurisdiction. And as you may remember from law school, to have diversity jurisdiction, you need parties that are completely diverse. They're from different states. And everybody thought, oh, look, we have diversity of jurisdiction here. East St. Louis is in Illinois, and all of these other companies are in other other states. And not only did the plaintiff's counsel think that, but so did the counsel for the streaming companies. But Judge Easterbrook did some research, apparently on the internet before the oral argument, and he traced the Warner Direct, the LLC. He traced it back and found it's actually owned by AT&T Capital Services, or it was at the time before AT&T sold off its Warner assets, which is located in Illinois. And this was revealed, of course, during oral argument. So the plaintiff's counsel begins making her presentation, and he says, let's talk about jurisdiction, because it looks like, we've got a defendant in Illinois, St. Louis is in Illinois. Can you please tell me, why this case shouldn't be dismissed? Don't you have an ethical obligation to dismiss this case? Plaintiff's counsel was completely blindsided, and frankly, so was counsel for the defendants, who had actually filed an amended jurisdictional statement saying that the Warner Direct was, I think, headquartered in Texas. So this was embarrassing for all. I think it certainly derailed a lot of the oral argument. And certainly there's just kind of no answer to it. So go from that horror to then some post-argument briefing, which established, wait, there actually is jurisdiction all along to the Class Action Fairness Act. And so there was a lot of drama, a lot of scary moments with stomachs and throats, hearts and throats. But it's all past. We get past that horror, but then we get to the merits of, okay, well, you can actually bring this lawsuit, we've established now, but can you win? And the Seventh Circuit says, no, you really can't. You can't win. We know the difference between a video service provider and streaming content. The implications here would be crazy in terms of streaming services. The plaintiffs point out that Illinois had recently changed the statute at issue to make it even more explicit that video content creators like Netflix aren't video service providers. The plaintiffs argued, well, that shows that the old version of the statute did include them. The court rejects that and said, no, this was a clarification. It wasn't a substantive change. The plaintiffs try to argue that there's a trespass going on under common law property, whereby look, these Netflix, they're streaming, they're trespassing without
classic
permission.
trespass,
Classic trespass,
pattern effects.
right? That's rejected. There's an argument that there's a resale of cable services that's going on here that the court just pretty quickly rejects. And so this legal effort by municipalities is once again thwarted, and they're going to have to go to the state legislature to see if they can get something done when it comes to streaming. But it's a good reminder that for counsel, when you're litigating, here's one more nightmare for you to worry about, and one more thing to plan and check is jurisdiction. Don't assume that you've got it, and don't even assume that you've got it if the other side says you've got it and provides information saying that you do, because everything can be searched on the internet. And I am sure that there were some associates on those cases who were probably staring down at counsel's table during the argument, thinking, "Oh, wow, I really should have checked that." So scary indeed.
Wow, that's definitely anxiety producing.
There's a lot that could be said about jurisdiction here, but I probably should be noted that this likely would not have happened in any other oral argument in the country before any other judge. But Judge Easterbrook is a big believer in jurisdiction and the court's own responsibility to bring up jurisdiction. And he did this in a recent IJ oral argument about a totally separate kind of jurisdictional idea. But he wasn't picking on us. He does this all the time. And the interesting thing about it is, though, in the end, yeah, it was the Class Action Fairness Act. There was jurisdiction anyway. It seemed like it was even, they pled this. It's just that it wasn't at the front of their minds when they get up for their 10 minutes of oral argument or whatever it was, which is another kind of scary thing about the Seventh Circuit is you do not know your panel of judges until that morning of the argument. So unlike a lot of other circuits where you get it a few days before, maybe a week beforehand, if it came out and it says, oh, this is a Judge Easterbrook panel, a prudent practitioner would then kind of get their jurisdictional stuff ready. But in the Seventh Circuit, you got to have that ready anyway, because you never know when this is going to come up. This also raises a ghost story that I think I have told on the podcast before, but maybe is time to retell it now, that one of my Seventh Circuit arguments when I was in private practice before IJ, it was just, it was a normal case. It was an arbitration case. And I have this Seventh Circuit argument, and the whole time I'm thinking, wow, I really hope I don't get Judge Easterbrook or Judge Posner on my panel. And we get the sheet that morning, 7:30 a.m., Judge Easterbrook's on the panel, and it was a real tough argument for us. We had told the client, this is going to be a tough one. And I get up there, and 2 minutes into the argument, or something like that, he's asking me if we have if what we're arguing is frivolous. Luckily, I had an answer ready for that because we knew this might happen, and we were not found to be frivolous, but we did lose the appeal. But it was a scary time. And there are many other examples of scary arguments before the Seventh Circuit with him and other judges on that court.
Yeah, oral argument's not going well when the judge asks you about your ethical obligation to dismiss the case, and that you've really got no answer as to why there's jurisdiction that remains. That is. It doesn't get much worse than that. I mean, I think you can. There's a more general lesson, I think, to be learned here, in addition to always checking jurisdiction, which is that questions, especially apparently before Judge Easterbrook, but before courts generally, can come from anywhere, any direction, which is why it's so helpful to moot your case beforehand, including with some attorneys who are not familiar with the record, not familiar with the facts, who are going to approach this with a fresh angle and throw some of those curveballs at you so that you have a chance to swing and miss at them in private before doing so in public.
Great point. Although I wonder if all the mooting in the world would have uncovered this jurisdictional defect.
I think there was probably some associate who was maybe they were tasked with this amended jurisdictional statement. I would not have wanted to be them on the return flight home, in terms of like, why didn't you just Google this thing? I mean, you could have just Googled it. I think there could have been some confusion because, as I mentioned, AT&T sold off, its Warner assets, and that happened during the course of the litigation, but you determine jurisdiction based on the outset of the case. So I think folks got tripped up there.
And the other thing that I didn't even realize, I never had to think about it before, but I didn't realize is if you're a corporation, right, your principal place of business or where you're incorporated is where you are a, quote, citizen for diversity jurisdiction. But if you're an LLC, you're considered a partnership, and therefore it's all your various, investors or owners and where they live, whether they're individuals or themselves LLCs or corporations. And that could get really complicated in some cases, considering how these LLCs are structured. So I think that's another scary story that some of our lawyer listeners should take note of.
Especially when you're dealing with these massive companies like
Right.
Netflix. They have so many parts and subparts, and if just one happens to have jurisdiction, I mean, that's very complicated and very hard to track down. Poor
This reminds
associate.
me of the case we read in civil procedure. So Bert may remember this, was the Pete Rose case, where when Pete Rose was banned for baseball, or the very beginning because of his gambling thing, he sued Major League Baseball, but he did it in Ohio State court, and he wanted to stay in state court because he thought he had a better shot there than going to federal court because, he was a hometown hero and all that. And the question was, is Major League Baseball like a thing, or is it all the subcomponents of it, all the teams, one of which is, well, a couple of which are in Ohio, and so therefore you wouldn't have complete diversity. And I think he did not win, is what I remember, but I don't remember the other details. So
you could say he lost that bet, right?
He lost that bet, and unfortunately, a few others in his life. Well, thank you both for your scary stories that our listeners can now think about when they're trying to get sleep tonight. And I hope everyone has a happy Halloween. I know both of you with your children will probably be picking their outfits or leading them around the neighborhood. Maybe not so much Erica, with hers is a little small for walking the neighborhood yet, but I will be supervising some of that myself. I know many of our listeners are. And the next time we speak to you, we'll have a fresh set of cases and a fresh set of guests. But thank you both for coming. And until the next time, I want everyone to get engaged.